Here to present a federal regulatory update for car dealers are Doug Greenhouse, NADA Chief Regulatory Counsel for Environment, Health, and Safety, along with Paul Mitri, NADA Vice President of Regulatory Affairs. Please give them both a warm welcome.
Good morning, everyone, and welcome to the 2017 version of the Federal Regulatory Update for Car Dealers. Paul and I have done this for a number of years, and it's a review of the most recent and important activities coming out of Washington, D.C. in the regulatory arena. Now look, you'll see on our title slide our contact information. You're going to probably go home and think of a question or two that you hadn't thought of during the session. Always feel free to contact us on anything we talk about today or on any other federal regulatory matter that arises at your dealership. We will try to leave some time for questions after the session today. It may be a little tight on time because we have a whole slew of information we'd like to go over with you today. Also, please come back down to the regulatory affairs portion of the NADA pavilion. Our booth down there has a wealth of information, some of which we're going to reference as we go through the workshop this morning. All right, we see we have a long list of items we're going to go through today. So who are we? We're the Regulatory Affairs Department of NADA. We represent your interests along with the interests of the commercial truck dealers before the federal agencies in Washington, D.C., who are always busy putting out new regulations, new guidance, new compliance responsibilities for your dealership operations and for the vehicles and other services and products that you sell. So what do? We advocate before those agencies, let them know how what they're doing might potentially impact your operations, suggest to them ways that they can do their job, the mandate perhaps that has come to the agency from a congressional directive, and do it in a manner that's less burdensome for you, perhaps involves less paperwork, so that it's not as much of a trial for you to actually reach compliance. Then we go out to you in presentations like this, in written materials, in emails, in our newsletters, communicate to you in every way, shape, or form that we can to let you know what your compliance responsibilities are and to make suggestions on how best to comply in a manner that's cost effective. Now, I do have this caution that we give every year, which is we're going to be talking about federal regulatory mandates. That's all we can do in the time allotted. We cannot go into the various state modifications on some of the rules that we're talking about today. And unfortunately, in our system of government, state entities as well as local government entities can regulate in manners that are sometimes stricter than or certainly different than the federal scheme. So pay very close attention to what your state ATAs tell you in regard to some of these responsibilities. Now, we're going through a transition. You might have heard that last November there was an election, and on the 20th of this month there was a swearing-in ceremony, or what we call inauguration, back in Washington, D.C. Big changes. Things look fairly favorable to the business community writ large. Why? Well, we have a Republican president, we have Republican Congress, and a Republican Senate. And when you have that triumvirate like that, you think all things being equal, they're kind of favorable to business, generally speaking, anti-regulation, anti-burden on business. And so it is generally thought to be a favorable environment. However, don't get your hopes too high, raised up too high, because we've seen this situation before. Through the years, there's been many transitions, many changes in power, and unfortunately, while we have a long list of issue areas of priorities that we've developed, and we've actually spoken with the transition team about, not all those items are going to get addressed. It's just the reality of the situation. There's plenty of other folks coming to feed at the trough like ourselves, and so there's going to be competing issues. There's going to also be situations in which they just cannot be as responsive as we would like them to be. However, if there are issues and concerns that you have, now's the time to let us know. Certainly feel free to communicate with us because we do have our priorities, but it also is very helpful to get feedback from the dealer body. Tax reform is going to be a major focus of attention in Congress, and there's a session, I believe, later today at 1:30 in which there's going to be some discussion of that. All right, let me get right into the substance of our presentation today in the interest of the time that we have allotted. You might remember that last year, the U.S. Department of Labor promulgated a regulation that comprehensively revised the overtime exemption for what we call white-collar employees. Those are the executive, administrative, and professional employees that you have at your dealership and that many other businesses employ across the country. Now, the deadline for the effective date of that regulation was December 1st, but it never happened. Why is that? Well, we, along with a number of other national trade associations, challenged that regulation in court, in a district court in the state of Texas, and were successful in getting that effective date enjoined. So the rule has not taken effect. Well, we've tried again to communicate that fact to you numerous times, and you've probably heard it from your local Chamber of Commerce and others. There's also litigation, there's still litigation ongoing at the district court level, but now we've also got litigation going at the Fifth Circuit level because the U.S. Department of Labor appealed the injunction on the effective date of the rule. That was the old U.S. Department of Labor. We remember, January 20th, a new sheriff in town. There's going to be a new deputy sheriff running the new U.S. Department of Labor. And so things are likely to change. If I were to predict, you're going to see the U.S. Department of Labor revise and reconsider this regulation. Probably won't get thrown out altogether. There is a provision called the Congressional Review Act, which could get rid of it altogether. I would not bet on that actually happening. But you can expect changes. So what's important, if you didn't make changes to your pay plans to be consistent with that new rule that came out last year, don't do it now, because the deadline's been enjoined and we don't expect these rules to, in the long run, to go final as they were written and drafted onto the books. So a couple other suggestions. Now should be the time when you take a look at and we recommended this last year as well, that you take a look at all your employees, you double check their compliance with the federal wage and hour laws, you make sure that if you are considering folks to be exempt from overtime, they are indeed meet the tests, whether it's the white collar test, whether it's the 7I exemption for commission employees, or one of the other exemptions to apply to dealership employees. You know, we're very lucky because our industry sector has a lot of overtime exemptions in most states. That apply to most employees. There are some that are non-exempt, you know, whether it's a lot person, whether it's a secretarial or administrative staff, whether it's perhaps a cashier. Those tend not to be exempt from overtime. But many of the other employees in the dealership environment are exempt. We talk about this at great length in our Dealer Guide to Federal Wage and Hour and Child Labor and Wage Discrimination, which you can see referenced on the slide. I commend you to get that guide if you haven't looked at it in a while. We did revise the guide to accommodate the regulation that came out last year. You could ignore that for now. We're going to have to revise the guide again. As I said, this rule is going to change again. But the rest of the guide is accurate with respect to the description of the federal wage and hour law. Again, this is an area where states can be different. States like California, New York, and others have tighter, different rules on wage and hour and overtime and minimum wage compliance. Many of the states, as you know, have higher minimum wages than the federal, so please pay attention to the state laws. Now, our guide also covers some other things. It describes in detail how best to pay commissions for commission employees, talks about the record keeping and the posting that you have to do to be in compliance, talks about child labor restrictions. For example, the teen driving restrictions on 16 and 17-year-olds, to the extent that you hire them, there's some pretty restrictive mandates regarding how much driving they can do on behalf of the dealership. Equal pay and compensation discrimination is a big issue with the EEOC and the U.S. Department of Labor. Pay close attention to those provisions. And then we talk about liability and enforcement, the fact that federal government can go back 2 years, 3 years if there's some intentional violations of these labor laws. All right, let's stay within the realm of wage and hour and overtime and talk a little bit about the status of service advisors. You may have heard that in 2011, the U.S. Department of Labor issued a regulation that reversed 30 years of guidance from the Department of Labor that service advisors were exempt on the salesman, parchman, and mechanics exemption as salespersons of service. Well, they call them salesmen of service. Then, in March of 2015, the Ninth Circuit, which is located in California, the Ninth Circuit Court of Appeals, ruled in a case involving a dealership from California that indeed, consistent with the U.S. Department of Labor's 2011 regulation, service writers are not exempt as salesmen of service. Well, we didn't agree with that, especially since 2 other circuit courts and a number of state courts and a number of other district courts had held just the opposite and consistent with that 30-year interpretation by the Department of Labor. So we petitioned for cert to the U.S. Supreme Court. The U.S. Supreme Court, as they very rarely do, accepted certification and heard the case in June of last year and ruled as follows. They ruled that the 2011 rule was inaccurate and inappropriate and unsupported by the record, and that so they basically threw out the 2011 rule upon which the Ninth Circuit's decision was based and remanded it back to the Ninth Circuit to reach a new decision. Well, the Ninth Circuit, being fairly wily and predetermined to reach a certain outcome, just this month on the 17th issued a second opinion saying this exact same thing but using different reasoning to justify the exact same position, which is that service writers are not covered by the salesman exemption. So where are we right now? Well, in those 11 Ninth Circuit states, if you're in one of those states, and these are the far western states, then you should take a look at your service advisors and treat them as if they are not covered by the salesman's exemption from overtime. What does that mean? That means, as a practical matter, you have to go to Plan B. And Plan B is to look at one of the other exemptions from overtime. Fortunately, our experience and our data shows that the majority of service writers are paid the majority of their compensation in the form of commission. And there's a 7I exemption from overtime that says if you pay the employee a majority of their compensation in the form of commission, if you pay them at least 1.5 times the applicable minimum wage, and that means whatever the minimum wage is, wherever your store is, then they are exempt from overtime under that exemption. You only need to have one exemption applied to employees. You know, I can think of scenarios in the dealership where as many as 3 exemptions from overtime applied to one particular employee, but you only need one to be exempt from overtime. So please, if you're in one of the far western states, the Ninth Circuit states, take a look at the application of the 7I exemption to your service writers if you want to exempt them from overtime. You don't have to, by the way, but we highly recommend it. Now, one last thing, if you're not in the Ninth Circuit, the law stays the same, that salesmen are that service writers are indeed covered by the salesman exemption from overtime. We haven't quite decided what we're going to do, whether or not to go back up to the U.S. Supreme Court. That is probably a greater than 50-50 likelihood. We're certainly going to go to the new Department of Labor and have them formally reverse their 2011 ruling consistent with the Supreme Court's direction. And we might even go to Congress to perhaps get some language that clarifies that service writers are covered by the salesman exemption. A few more labor issues, and then we'll turn it over to Paul. There is a mandate that applies to every single dealership, which is to keep records of your workplace injuries and illnesses. This has been around for the light-duty dealers only since 2015. Before that, they were totally exempt from having to keep what we call injury and illness records. The commercial truck dealers have had this responsibility for a long time. What's changed is recently there was a rule that required that not only do you have to keep the record the data, you also, if you're a large light-duty dealer, that is one that has more than 250 employees per establishment. Now, what's an establishment? Think of an establishment as a store, one physical address location. If you have more than 250 employees employed in that location, you not only have to record the information, you have to periodically report the information to the U.S. Department of Labor. Again, all commercial truck dealers have to also report the information. Now, specifically, that data is due on July of this year for last year. But to date, the U.S. Department of Labor has not put up the online website filing the data that they said they were going to do. And again, we have a new Department of Labor. And a number of folks have challenged this regulation in court. And you can bet there are a number of folks are going to run down to the new Department of Labor and ask them to revise the reporting mandate. So stay tuned between now and July. Pay close attention to what we tell you about this, because it could very well be that this thing's going to go away. But for now, we do have that July 17th deadline. Tied to this issue of injury and illness reporting is a requirement that came out in August of last year called the anti-retaliation provisions. What it basically says is, look, employees have the right to report injuries and illnesses to you. And they should not be inhibited in being able to do so. If they're indeed injured or suffer an illness that's work-related, they should be giving you that information, and you should be documenting it. In fact, this poster that you can see up here is the latest version of the DL poster that you should have posted somewhere in the dealership, primarily where you keep all your other federal regulatory and state regulatory posters, for the employees to see, to informing them of their rights to make these disclosures. You can technically communicate this information to your employees in other ways, but I recommend you use this poster to do so. Now, again, there have been some court challenges of this provision, but let me tell you how it sort of plays out. For example, it's not unusual for many dealerships, especially where state law allows, to have what we call post-accident drug testing. There's an accident, someone falls off a ladder, they crack their head open, and typically in many dealerships, they immediately send that person to get drug tested to see if they were under the influence of a drug when that accident occurs. Well, that's no longer allowed. You cannot have a blanket drug testing policy because to do so would inhibit the person from reporting an injury or illness. And so what we recommend is that you only drug test where the law specifically requires it. For example, dealerships in the commercial truck space, some of their vehicles have to have a commercial driver's license. And if you have to have a commercial driver's license, one of the requirements under federal law is that there be post-accident drug testing. That's an exemption, an example of an exemption from one of these requirements. But also, if indeed you have reasonable suspicion that someone has been under the influence of the drug when they were injured, you can drug test them as well. But you can't just do it blanket across the board. On the carrot side of the ledger, it's not unusual for folks that are trying to encourage a safe workplace to incentivize employees by saying, look, if we have a month where there's absolutely no injuries, then we're going to have a pizza party, or I'm going to hand out, as we show up here, lottery tickets. Can't do that anymore because, again, that the Department of Labor has taken the position in guidance that will incentivize the employees not to report an injury that would otherwise have been reported because they want to get that spiff or that benefit. And lastly, let me, before turning it up to Paul, just mention the fact that there's a brand new fall protection rule that came out last year from OSHA. It talks about, it revised the 40-plus-year-old rule that governs what you should do as an employer to try to prevent injuries that arise from workplace slips, trips, or fall hazards. Try to eliminate those hazards in situations where you can't eliminate through engineering controls or making modifications to the facility to actually have safety, personal protection, other safety devices put into place. Now, there's an exemption that's always been on the books for climbing around on top of vehicles, and that activity has always been exempted from this provision. That exemption, we were able to get that exemption to continue moving forward. The rule actually took effect on the 17th of this month. The training deadline for employees that have to be trained on what they have to do to avoid slips, trips, and falls is May of this year. So pay close attention to that. And here's one of the provisions that's brand new. How many of you have pits in any of your service facilities? I'm seeing one or two. Okay. It's probably not something that's on every single store, but it's not at all unusual in some of the older stores or quick lube lanes or whatever it might be. Here's the requirement if you have a pit that's less than 10 feet deep. You have to have You don't have to actually have fall protection systems that the employee must wear if you limit access to the pits and going within 6 feet of the pit edge to those employees that are authorized and trained to be in the pit or around the pit. Make sure that you have contrasting floor markings at least 6 feet from the pit edge with a warning line or tip resistant stanchions at least 6 feet, like I said, from the pit edge, and then visible caution signs stating caution, open pit. The whole idea here is, even though probably everybody in the service department knows there's a pit and very careful around those pits, that you don't have a situation where someone falls into the pit and gets injured. So that's what that rule is all about. We're going to put out guidance on this. It's already being worked on. Stay tuned on that, and look for it in your email box. One more before we turn it over. The EEOC, which is the agency that regulates discrimination at the workplace, has really ramped up under the Obama administration. Its focus on discrimination based on in a number of areas, but particularly discrimination in pay between males and females. One of the things they've done is put out a mandate that the new EEO1 rule for 2017 data has to be complied with. Now, they did extend your filing for 2017 data until March of 2018. Normally it was in the fall, so they give you more time to file, but you're going to have to file 20 times the amount of information that you historically have filed with an EEO1 form, including W-2 wage information by job category. So it's going to be a real pain, unless the new DOL, or in this case the new EEO, changes the mandate, and we expect that they may very well do so. So stay tuned on that. Paul?
We are looking at the most significant regulatory developments that affect your operations at the federal level. Doug has teed up a number of them, and we're going to continue on that path. Keep in mind we have a twin function, and the twin function, of course, is to advocate on your behalf and also to educate. Developments coming out of the federal regulatory agencies. We're engaged in the latter process right now. It's never to give it legal advice, but certainly to let you know what's going on, which is what we are attempting to do. Okay, with that, let us start with the agency that is most pertinent to your operations, the Federal Trade Commission. They are really the federal enforcer of much that auto dealers do. Incidentally, they recently turned 100 as well. They've been around for a while, and the number of requirements that they're enforcing they put out is always on the increase, as it is with many agencies. So let's take a look at the significant activity from the Commission in recent months. And the most notable one is the FTC used car rule. After an 8-year process, they just finally issued a new amended rule. Now, this is the rule that's been around since the mid-'80s. It requires the buyer's guide on the used vehicles that you sell. I think everybody's familiar with that. Well, this has been quite the process. They initially proposed a rule that industry could live with, thought it was not bad. Consumer groups went nuts about it. They re-proposed a rule that we thought was very problematic. Industry went nuts about it. They have since re-proposed a third rule that's along the lines of the first, and I think you'll find that for the most part it's quite manageable and in some ways even helpful. So let's take a quick look at that. First, the rule takes effect, interestingly enough, yesterday. However, you may use your existing stock of buyer's guides for up to 1 year before you adopt a new one, assuming that you do have an existing stock. If you do not have an existing stock, you have to start using these other ones immediately. And there's one exception to what I'm telling you about, which I'll flag in a moment. Keep in mind, if you are in Maine or Wisconsin, you have your own FTC-approved version of the buyer's guide, so speak to your state associations about what those requirements are. Okay, let's talk about what the changes are. Now, the first thing to put you at ease, I know you see a lot of ink up there. You're thinking, oh my goodness, here comes a major new regulatory scheme. We have to do this all the time. Everything you see on this slide is pre-printed boilerplate. Now, there's additional changes I'll get to in the next slide. But this is all pre-printed boilerplate. You don't have to do a thing. You don't have to make an election. It's just what shows up on the new buyer's guide that you're going to print off and put on your vehicles. So they have a new statement for as-is sales. They also have added new statements about where consumers can obtain a vehicle history report and check for open safety recalls. That's at safercar.gov. That's that NHTSA lookup feature that's been around since August of 2014. You plug in the VIN, you can immediately find out what its safety recall status is. Incidentally, I'll be touching on that again when we get to the topic of advertising because it feeds into that topic. And also the list of major defects, they added 2 of them. But again, when you print out the form, it's just going to show up. So you don't need to do anything other than use the new buyer's guide once the existing stock expires. Now let us continue. These are things that actually do involve your involvement, some decision that you have to make. The first, non-dealer warranties. And every dealer I've spoken to has said they think this is a positive improvement. For a long time, you've struggled with how do I disclose the presence of a non-dealer warranty? And why is that an issue? The FTC does not want you tinkering with their form. When you read the rule, they are incredibly explicit about what you can do and what you cannot do, what the font has to be. It's very much locked in place. They don't want you tinkering with it. They don't want logos on it. They don't want any of these other things. However, they're now saying, look, if you have a non-dealer warranty, not just a manufacturer's warranty still applies, there was actually a way to disclose that on the current form, but also a manufacturer's used vehicle warranty applies or some other used vehicle warranty applies. In other words, some type of non-dealer warranty, there are now a box you can check to disclose that. So you do have that ability, and when I said there was an exception to the effective date of this regulation, if you choose to check one of these boxes, if you want to disclose the presence of a non-dealer warranty, then on your existing forms, you would have to use certain language which we have provided to you. I will mention that in a moment. Or you can simply just start using the new form. But remember, these boxes are optional. You are not required to check them. But if you do, you have to put the right language. Signature line. Previously, you were able to put an optional signature line where the customer acknowledges receipt of the vehicle. That was on the English form. They now have a Spanish translation that is also available to you. And also, I should mention, and I'm just going to go up here, when I mention the new statements added, keep in mind there is a new statement on the English buyer's guide that's in Spanish that in essence tells the consumer to ask for a Spanish language buyer's guide if the dealer is conducting the sale in Spanish. Remember, if you conduct a sale in Spanish, you have a Spanish-speaking salesperson that is conducting the sale with a consumer in Spanish, you need to have a Spanish language version of the buyer's guide that goes onto the vehicle, and that also has to be provided to the consumer. So this all is a continuation of that obligation and a clarification of it. Now, in terms of FTC resources, they have a press release, you have the URL here. They have their own dealer guide that they release at the same time of this rule. So there's a dealer guide out there. We are amending ours to reflect the changes, but there is a current one on the street from the FTC that you can access. We have also sent a summary of the changes to dealers in an all-member email that was sent out on 2 different occasions. And also, we are going to have a webinar that the FTC is committed to providing a staff attorney that works on these issues to, that we'll be advertising very soon, because often there's a lot of specific questions about how do I fit in this or do that, and we want that person to be able to address those issues. If you did not get the all-member email because it's stuck in someone's inbox, you have no idea where it is, it got caught up in the spam filter, whatever it is, please send an email to regulatory-affairs@nada.org and ask for the used car revision memo that was sent out to all members, and we will get that to you. Just identify the dealership and they'll be sure to send it to you. Okay, this is what the buyer's guide looks like on page 1. Now note, there are some differences here. If you are in a state that permits as-is sales, you use one version. If a state that does not permit it, there is another one. And then if you go to page 2, you will note that page 2, or I should really say the back of it, is the same. This is how it looks. You'll notice there's some blank space there for that optional signature line. But anyway, this is the general look of it. Now, one thing the FTC has provided is a fillable form. If you're saying to yourself, oh my goodness, I have to go to the forms company, have they programmed it? You can go onto the FTC's website right now and get these forms that you just fill in. And we provide a link to it in the memo that we sent to all dealers. So you click on that link, it takes you right to the form. So that is available to you. And again, we will be having a webinar very soon with the FTC that will further explain this situation. Okay, let's talk about advertising enforcement. Now, I have to tell you, advertising enforcement is one of these issues since 2012 that is ever present. I used to start my discussion with advertising issues by giving you a tally. You know, the following states have had advertising actions against dealers, and the list kept growing and growing and growing. I finally discontinued that. Trust me, at this point, they're all over the place with these actions. They are hitting on a number of things. Just at 30,000 feet, what are they? Remember, under the Truth in Lending Act and the Federal Consumer Leasing Act, or the regulations that implement them, Regs Z or Reg M, if you use certain trigger terms in an ad, you have to have certain follow-on disclosures. And here's the kicker. They must be clear and conspicuous. If they're not clear and conspicuous, effectively they're not present. So they need to be something that the consumer can see. So they've hit on that issue quite a bit with dealers. They've also hit on what they say are deceptive statements. Anything that's material to the ad needs to be there. You'll say, what's material? What's important to the consumer to actually understand the terms of the ad? That needs to be present, and again, it needs to be clear and conspicuous. You cannot omit that. You got to make sure they can read it. So those are kind of the themes that they have enforced on. It has to do with negative equity advertising, these sign and drive leases, and on and on and on. There's several of them, but they've really looked at that. What has the activity been lately in this regard? Well, there was a concern about the VW buyback program. I was contacted by an FTC enforcement attorney in August, and he said, we are seeing ads from VW dealers, or other dealers for that matter, that are misrepresenting the situation that pertains to the VW buyback program. That says 2.0 liter vehicles that you could have VW buy back. There were statements made about trades and other things that concern the FTC. We responded by simply saying, we'll set up a webinar, express your concern to dealers, and hopefully the situation will improve. We did that in September. They did the webinar, and we've not heard from the FTC lately that this has been a concern, so hopefully that has been addressed. Also, spot deliveries. Now, this is important. Please note, for many of you, this is probably a relevant consideration if indeed you do engage in these conditional deliveries. And that is as follows. The FTC took an action against an LA dealer group. It was a multi-dealer group, I think 9 stores. And the action they took against them was for alleged advertising violations and many other items, one of which is payment packing. Another of which, for the very first time, is spot delivery abuse allegations. So we've told dealers for a while there are investigations pending with the FTC, but they were lingering. They have now actually taken an action where they've made these allegations. And I'm not going to go through a compliance course on spot deliveries right now. Needless to say, their concern is when the consumer does not understand their rights in a transaction. So if you cannot assign paper on the terms submitted and you want to recontract, the recontracting is not mandatory. That's optional for the consumer. The consumer has to know that. The consumer is supposed to get anything they gave you back unless they do agree on their own volition to go ahead and enter into a recontract. So they need their trade back, they need their down payment back. Those type of things you got to be very careful with. So always make sure the spot delivery procedures are not going to be something where the FTC can say the consumer did not understand the situation and was railroaded into a recontracting deal. You want to avoid that allegation. Also, one thing I do not have on here, which happened after we had to turn these slides in. So it's very recent. And I mentioned earlier I was going to mention the used car rule again as it relates to recalls. And here's the situation. For some time, the FTC has been investigating dealers for statements that are made in used vehicle ads that include safety inspection claims. And they just finalized 3 proposed consent orders, and they just initiated 3 more proposed consent orders. So what's the issue? It's this. If you have a used vehicle ad with a safety inspection claim, now that does not mean the word safety has to be in the ad. It can be express or it can be implied. How is it implied? Well, they've given 3 examples, not that it's limited to this. You talk about a used vehicle being certified, pre-owned. You talk about a quality assurance inspection. You talk about a multi-point inspection. Any statement like that can imply the vehicle is safe to drive, at least in terms of what the FTC thinks the average consumer and how that average consumer would perceive the ad. So if that's present, used vehicle ad, and it involves a safety inspection claim, they have told these dealers that they have a duty in that instance to tell the consumer that the vehicles may be subject to an open recall and how they can figure out its recall status, which of course is a reference to that VIN lookup feature at safercar.gov. And that needs to be prominent, like I said, clear and conspicuous, or it's not present at all. And we're not just talking about billboards, we're not just talking about your Sunday newspaper ads, we are also talking about the web. If those vehicles are popping up and they could be potentially subject to an open safety recall, if you're positive none of them are subject to an open recall, this does not apply, but this is where that potential exists. And in today's environment, that frequently is the case. You must put that disclaimer in there. One other requirement, if you are selling an in-brand used vehicle, and the factory has told you through a communication that the vehicle is subject to an open safety recall, you must provide that to the consumer prior to consummating the transaction. So that you must provide either the manufacturer communication or something that is substantially similar that gets the information to them so that they understand the status of the vehicle. And by the way, there's many other considerations on recall vehicles. Doug will hit on a couple. The fact is, it's an area that is fraught with peril. You've got to operate very carefully, but on the advertising front, that is what the FTC has looked at. Okay, let's move over to the Military Lending Act and talk about that for a moment. Now, why are we talking about this issue? DOD is not typically an agency dealers have really had much interaction with, but I will tell you there is a rule out there that could potentially affect your operations. And I'm going to give you the short answer up front and then explain it. Please talk to your attorney about what I'm about to describe to see if it affects your operations. It is an unsettled issue. We have a perspective on it, and we're seeking clarification of it, but it's an unsettled issue, and it behooves every dealer to talk to their counsel on this issue because the consequences for noncompliance, if this applies to you, are very significant. What is the Military Lending Act? A law that's been around for 10 years to protect service members and their dependents from abuse of credit products. It initially covered only 3 narrow categories of credit that did not apply to you. Refund tax anticipation loans, auto title lending, certain payday loans, not things that you do, really not an issue. They significantly expanded the coverage in 2016. On October 3rd, they basically said if it's credit that's covered by the Truth in Lending Act, for the most part, it's covered by the Military Lending Act. Now, if that were all there were to it, there'd be no question that you'd be covered because you comply with the Truth in Lending Act every day when you make these disclosures about things like finance charge, amount financed. That's all the Truth in Lending Act and Reg Z. However, there is an exclusion, and there's 2 of them that are relevant. One is if you are entering into a finance transaction to finance the purchase of a motor vehicle, that is excluded, or other personal property. Now, what does that mean? Well, we have always thought that means that it's not just financing the vehicle, but other related items. Sales tax, related ancillary products, negative trade equity. These are things related to the transaction in our view. So we have always felt that it attaches to that, but DOD came out with an interpretation that really calls that into question. So let's take a look at that. In August, so this was about 6 weeks before this took effect, without any prior notice, they issued this question and answer. And I'm not going to read the whole thing, you have it, but suffice it to say they want to know if a creditor extends credit for the purpose of purchasing personal property. Does it fall within the exception to consumer credit? In other words, is it excluded from these requirements where the creditor extends credit in an amount greater than the purchase price of the vehicle? Look at the answer, no. Drop down to the red language if you can make out the red language a little bit lower. To qualify for the purchase money exception from the definition of consumer credit, a loan must finance only the acquisition of personal property. So needless to say, this got a lot of people concerned. They were talking about a different exception, a personal property exception. Ours is the motor vehicle exception, but they are identically worded. The concern was if they feel that way about personal property, do they feel the same way about the motor vehicle exception? And the issue becomes, if we're financing something other than just the motor vehicle, does that take us out of the exclusion and mean we have to comply with these whole sets of duties? And that is a $64,000 question here. So we asked them to clarify. Regrettably, they did not prior to the effective date of October 3rd. So we quickly went to a law firm that specializes in this area, and we said we need to provide our members some informal guidance, some direction on the issue that they can take to their attorney and discuss with them. Can you provide an analysis of it? They did that for us, and they explained the following. In essence, they think the motor vehicle exclusion, what takes you out of these duties, applies to more than just financing the motor vehicle. It also applies to things like the sales tax. It applies to related ancillary products. It applies to negative trade equity, because those are items that are related to the purchase. What DOD was concerned about was when you have basically cash out financing that's unrelated to the purchase. And I will tell you right now, if you are extending credit contracts to customers where you are providing cash out financing in addition to everything else, then that is something that's going to take this, we think, outside of the exception and impose these duties on you. So you got to be very careful here. Now, one big caveat. This was just a law firm giving its thoughts on the matter. This is not a court case. This is not an agency decision. That's why I said this issue is unsettled. I have asked DOD to formally clarify this. I've sent a letter on behalf of NADA that has basically said, please tell us if you think these standard motor vehicle financing transactions that finance more than just the purchase of the vehicle, they also have these other items that we think are related to the purchase, do they fit within the exception? And that request is pending, and we will notify you as soon as we hear something. Incidentally, when a big development occurs, Doug and I make sure it's posted at NADA headlines. That is something that goes out every single day. It's our e-newsletter, and we have an announcement, and usually we link over to some more information. So please stay tuned on that. Now, in the event that the Military Lending Act does apply, what is it you have to do? In other words, if you said to yourself, I'm not going to roll the dice on this, I'm going to start applying, well, there's a lot to it. First of all, you got to figure out, is your customer a service member or a dependent that these duties apply to? And then you have to figure out, is the APR, there's something called the military APR, over 36%? Because if it is, you can't do the transaction. And if it's lower than 36%, you can do the transaction, but you got to make certain disclosures. And the military APR, I don't want to get into that concept in any depth here. It's too confusing. Just suffice it to say, there's an APR that you disclose today under the Truth in Lending Act. That has not changed. You still disclose that. The military APR is basically a separate calculation you do on the side, where you basically take certain things today that you put in the amount financed, and you have to move them over to the finance charge, and they detail what those are. Things like credit-related ancillary products. And if that finance charge grows to over 36%, you cannot do the transaction. If it's under 36%, you can, but you got to make both written and oral disclosures, and there's also certain things in your contract you have to change. For example, you cannot have arbitration agreements put in there. So it's a big deal if, in fact, this does apply. Penalties and enforcement. Why should you take this seriously? Well, obviously you want to be compliant, but there's also significant consequences for not doing so. You see them here. There's all kinds of both criminal and civil liability. So we have said to DOD, look, it's imperative that you clarify this. There are businesses out there where they really should have the peace of mind of knowing they do not have to take these additional steps. And by the way, we don't think the law was designed to address the standard motor vehicle financing transaction. It is not an abusive credit product. It's been around forever. The Federal Reserve Board in Reg Z has a number of disclosure requirements. It's also subject to unfair and deceptive act or practice authority that the FTC has. So we've made a compelling argument, we believe, as to why your standard transaction should fit in the exclusion. But again, please talk to your counsel about it. Okay, let me finish up by saying a couple words about the CFPB. Now, this is kind of interesting. If you've been to any of these sessions the last 4 years, this is the number one topic, right? We're spending half the session on it, and we're struggling to get off of it. Well, I'm pleased to tell you the situation on this particular issue appears to be trending in the right direction. And that is because of the efforts of a lot of people, but in essence, here's what happened. As you know, there's been some competing visions of how this issue should be resolved. The CFPB has wanted to eliminate dealer participation. They want dealers to be compensated by a flat fee. They do not want dealers to get a portion of the finance charge that's subject to negotiation with the customer. We have always pushed back. We have said, look, we think that dealer participation is enormously pro-competitive, pro-consumer. It is one of many methods that should be allowed in the marketplace. And what the CFPB has pushed all along has been a consent order they entered into with Toyota. Their hope was that they would basically obtain what they call a market tipping consent order. If you get one company to adopt it, all the others will rush to the safety of the terms of that consent order, and then you effectively will move the market without having to get a change in the law, without having to get a change in the regulation. You avoid transparency, you avoid pushback, lawsuits, et cetera. They have not been successful with that. The other finance sources have not moved in that direction. And just in December, on December 16th, the person that is the architect of this policy at the CFPB put out a blog where she said that they are reprioritizing their work. They're shifting their focus to other issues, other fair lending issues. That does not mean this issue goes away, but it means the massive pressure that's been applied to finance companies does appear to have subsided, and that was going to be the way they're going to try to get dealer participation eliminated, since they do not have direct jurisdiction over auto dealers. So we think this issue is going to wind down nicely, or at least it's pointed in that direction. But let me just tell you, and I'll finish on this point, it is not a foregone conclusion, because the leadership situation at the CFPB, unlike these other agencies, has not changed yet. These other agencies, you've heard all these nominees, they're being confirmed, they're being debated, they'll be populating these different agencies. Richard Cordray at the CFPB has a term that runs through August of 2018. It's very possible the president will seek to remove him. That will likely trigger some type of litigation, and it could be an unsettled situation. So we have a lot of priorities, a lot of things we want to pursue with the CFPB under the new leadership, but when that occurs is uncertain at the moment because of that leadership situation that has not resolved itself. So on this issue, again, this is why it's not dominating the agenda. We think it's moving in the right direction. We still encourage dealers to adopt our optional Fair Credit Compliance Program. There are other threats out there than just the CFPB. You have the Department of Justice, your state attorney general, you have the private bar. Remember, the whole reason finance sources put rate caps in place 10 or 15 years ago, all of that preceded the existence of the CFPB. It was due to private litigation, and it was based on the same theory that the CFPB has advanced. So there's a lot of exposure in this area. You always want to be able to demonstrate compliance. This optional program is a way to do that. It's based on a DOJ model. Every individual dealer that adopts it comes up with a standard dealer participation rate that they apply in dealer participation transactions, and they only deviate downward for pre-established legitimate business reasons, and they document it. They take some other actions to make sure the program is implemented appropriately. We believe it's a very important step forward. Attorneys all over the industry have said the same, and we think it's something from a risk mitigation standpoint you should take a very hard look at if you've not done that already. So on that point, we're going to shift over to Doug on a couple remaining issues, and then we'll take your questions.
Thanks, Paul. Let me touch on safety recalls for just a minute here. This is something that's been with us for a few years now. Even though the law has been around for 50 years, we've seen a tremendous growth in the number of recalls that the National Highway Traffic Safety Administration, in conjunction with the vehicle manufacturers, have conducted since 2014. In addition, of course, of those recalls, we've seen a huge growth in the number of vehicles that have been recalled. So it ranges up to about 60 million for the past couple of years on average. So what's the key issue? I think that we have, it's important to note that last September, we revised this Q&A document that covers in just 3 pages a good amount of information that you have to pay closest attention to as dealers that are acting as the focal point for achieving the effectiveness of the manufacturer's safety recalls. The comprehensive revisions that were made in September build upon, I think, the guide that was out for another 2 years prior to that, but give you some specific information. By the way, the guide is available from our website only. It's not something you can go down to the booth downstairs and get a copy of. It's password protected. Why are we kind of limiting its availability through this mode? It's primarily because there's some fairly sensitive information that we want dealers and dealer employees alone to take a look at. It's not for general attribution. So please, if you need a copy of the fairly new revised guide, go to nada.org/regulatory affairs, which we said earlier today has a wealth of information on a huge number of topics that unfortunately you as car dealers and managers have to comply with as a function of being in the dealership business. Let me talk a little bit about what exactly is mentioned in the guide. First of all, we talk about new car sales. The statute, for over 35 years has had a provision that says you cannot deliver to a customer, sale or lease, a new motor vehicle with an outstanding, unremedied safety recall. So it's important that you instruct and re-instruct your new vehicle sales staff in that regard. From time to time, unfortunately, deliveries are made, and there have been a couple enforcement actions by NHTSA when they've caught wind of it. So please be careful about that. Now, ostensibly, the statute contains a provision that compensates you for keeping those vehicles in inventory to the tune of 1% per month prorated of the price you paid for the vehicle. The vehicle manufacturers, to a greater or lesser degree, actually end up paying you that. I know some manufacturers are much better than others. They state very explicitly, typically in the dealer notification letter that's required by statute, whether or not to what extent the recall covers new motor vehicles and the degree to which they're going to compensate you for keeping them in inventory. The second issue, of course, and probably the one that's much more controversial, much more concerning, is what do you do with used cars that are covered by open, unremedied recalls? If the parts came out to fix the vehicle at the same time as they announced the recall, we wouldn't have an issue. We get the parts, we fix the vehicle, and everybody would be happy. But unfortunately, one of the dynamics that has occurred over the past 10 years is manufacturers are being forced to make what we call the recall determination earlier and earlier and earlier, in part because they've been forced by statute to collect data from around the world that shows a potential defect or non-compliance earlier and earlier and earlier. It's a kind of a function of just the nature of technology and collecting data from dealers, from accident reports, from testing, et cetera, that shows that we've got a problem. We got to perhaps issue a recall, and then they're also risk averse, so they're making determinations that indeed we should do a recall, whereas in years past maybe they wouldn't even have conducted a recall. So earlier determinations, a greater number of recalls means more and more vehicles on your lot of your brand or other manufacturer's brand that have an open recall that cannot be remedied because the parts are not available. So what do? Do I sell the cars or not? Well, the law has always allowed you to retail a used vehicle with an open, unremedied recall. So 50 years, again, the law's been around, it's been legal, it still remains legal to sell that vehicle. However, there is prospective liability. If indeed the scenario were to arise where someone would get into an accident and the argument would be made that indeed that accident was caused by something related to the defect or non-compliance for which the vehicle was recalled, someone gets injured, someone, God forbid, gets killed, there's property damage, you can bet they're going to knock on your door and sue you for having retailed that vehicle, because that's the nature of our legal system. In addition, a number of manufacturers, and most of you in the room probably have seen this, have said from time to time that we don't want you selling used vehicles covered by this particular recall. In some instances, there are brands that have said across the board, we don't want you retailing used vehicles on your lot covered by this open recall. Now, they don't tell that to your competitors that have the exact same vehicles on their used vehicle lot. They only tell it to their own dealers because that's the only dealers that they have jurisdiction over. There's been pressure put on them by the old DOT to do that. We're hoping that the new DOT will have a change of attitude, and we are certainly in conversation already with the transition folks about taking a second look on this issue of grounding used vehicles with open, unremedied recalls on your lots. Now, what we do say in this guidance document is, if you sell a vehicle with an open, unremedied recall, disclose. You disclose prior to sale to that prospective purchase or lease customer. They decide they want to buy it. They sign the form that you make the disclosure on. It does at least help protect you, because more often than not, when I talk to dealers, the sales staff tells them about the open recall. The customer says, I don't care. I want that vehicle. And what can I sign so that you will sell me that vehicle. And that seems to be the predominant scenario when that situation arises. But anyways, please take a look at that guide and think about how the policies that you're going to adopt in your particular dealership regarding the sale of used vehicles with open unremedied recalls. Just very quickly, the NHTSA has a VIN lookup site. Since 2014, it's been possible for you to run a specific VIN. It's capture protected, and it'll tell you, the screen will pop up as to whether or not it has an open unremedied recall. If a recall is fixed, you report it to the manufacturer. It's going to get into the manufacturer's database, and so if you run a VIN or some other dealer takes that vehicle in on trade, you run the VIN, you will not get a screen that says there's an open recall. There will be no showing of an open recall. But it's very useful, especially with the off-brand inventory, to use this VIN lookup tool. Some of the vendors on the floor claim to have systems to allow you to look at a broader universe, perhaps even up to including your entire used car inventory as to the their recall status at any one point in time. But this is the official NHTSA VIN lookup site that we're commending you to. Rental vehicles are by law grounded. If you have a rental fleet of more than 35 vehicles in the fleet, you cannot rent the vehicle with an open unremedied recall. So keep that in mind. And lastly, service customers, there's a provision in the law that effectively penalizes you if you do not tell a service customer that they have a recall on the vehicle when it's brought in for unrelated service. It authorizes the manufacturer not to reimburse you for the recall. Now, it doesn't really make sense, the statutory provision, because what are they going to be reimbursing you for if you haven't told them about it and they haven't gotten the recall fixed? I don't quite understand that, but the general caution is your service advisor should be advised, and I'm sure the manufacturers, most of them anyways, have stressed to you to advise your service advisors to check for open recalls on those vehicles when they're brought in for service, and of course to get them remedied, since it is free to the customer and money in your pocket.
Thank you very much for joining us. If you have more questions, please just come to the front. Thanks a lot.